My name is Teresa Stadheim, and I'm going to give you a short presentation today about functional claiming from the perspective of software and electrical patent attorneys. When considering a software invention, we're typically trying to claim functions that are being performed by the software. However, by functionally claiming your invention, you open yourself up to the possibility of indefiniteness rejections. My talk will show you how to avoid having your claims interpreted as functional claims and how to avoid indefiniteness rejections, assuming that you do get interpreted as functional claims. First, I'd like to just give a real quick history of functional claiming. I usually start off with a case of Samuel Morse as a ham radio operator. I find this case quite fascinating. Basically, the Supreme Court sustained Morse's right to a patent for a repeater apparatus means for transmitting via telegraph, but they explicitly denied another set of claims that tried to claim all uses of electromagnetism. I think Morse's case is significant with regards to the history of functional claiming because it indicates the Supreme Court's general wariness towards functional claiming, which is often defined as the practice of describing an invention according to what it does rather than what it is. 100 years later, the case law moves from telegraph poles in the sky to oil wells deep in the bowels of the earth at the Halliburton versus Walker case. Now, this case is often credited with giving us functional claiming because the Supreme Court here held that the patent was invalid because Walker did not describe the invention but used conveniently functional language describing what the apparatus will do rather than the physical characteristics or arrangement of the new apparatus. And there was a bit of an uproar after the Halliburton case because many people thought that they should have been entitled to a patent here. So some people credit this case with giving us the functional claiming that we find now in the Patent Act. So in 1952, after Halliburton versus Walker, when Congress was revising the patent law, some means plus functional claiming is written into the statute. Functional claiming was now allowed, but the scope of such limitations was restricted to the structure and equivalence of the structure disclosed in the specification. After the 1952 Patent Act, examiners would decide whether functional claiming interpretation should apply by asking three questions. The first one was whether there was use of the word means or a generic placeholder for means, and the second, whether means or the generic placeholder was modified by functional language, like by transition word. And third, if the term means or the placeholder was not modified by sufficient structure to perform the claimed function. If the answer is yes to all of this, then the claim was interpreted under 112F. However, you should also keep in mind that even if claims are interpreted as functional claims, this is not in itself a rejection. Instead, what often happens later is that the examiner will find an indefiniteness or written enablement rejection. We just mentioned the word means and generic placeholder words. Generic placeholder words are also known as nonce words. And if the examiner thinks that the words that you're using are nonce words, then 112F might apply. However, it's kind of unclear, it's kind of murky what words will qualify as nonce words and what won't. So I'm showing you a list here. This is taken right from the MPEP. One of the lists is nonce words and one of the lists is not. Now, if you remember from one of the previous slides, nonce words would often, the nonce phrases would often have a transition word in them, such as for. So here you see the word for is in all of the words on the left side, but then for is also in a couple places on the right side, so it's kind of unclear from that perspective. You can't just say just by avoiding the use of the word for, you're necessarily going to be able to avoid means with function interpretation. And also whether the words themselves denote structure is one of the key ideas to keep in mind. And we see on the left, there's a lot of the words here that do denote structure, such as device, member, apparatus, machine. To many people, those should all invoke structure. And so it kind of just seems unclear what words will invoke 112F and which ones won't. Now here's the answer. All the words on the left do invoke functional claiming interpretation, and all the words on the right do not. And these are all, again, taken straight from the MPEP. You can look up the case law. The cases themselves are also listed right in the MPEP. So I'm going to go through a few more examples taken from the recent case law that will help you figure out whether you think you're going to invoke functional claiming interpretation or not. The first example comes from my firm. We had the word, the claim language recited security system control panel. Now, originally the claim just recited control panel, and there was a control panel shown in the specification. There was some wires coming out of it. And when you think of a control panel, a lot of people will think of buttons you're pressing, and they'll think of a physical structure. However, the examiner was not convinced by that. They still thought we invoked functional claiming interpretation. So we amended to add security system control panel. And again, you think of a security system control panel as a physical structure, and the examiner still was not convinced. Now, it finally did convince the examiner. Now, note this phrase here was found to invoke 112F, but what we did do to get over that was we showed interaction between the security system control panel and other elements of the claim. So that's the first example. Now, the second example is taken from the infamous Williamson case, which some of you might remember from June 2015. And here the patent described methods for distributed learning that utilized industry standard computer hardware and software linked by network to provide a virtual classroom environment. So originally the court thought the word module did not invoke 112F, or means was functional interpretation, but the Citrix sought en banc review. Sitting en banc, the court withdrew that earlier opinion and also reversed the previous precedent from other cases that stated that a strong presumption, that stated that there was a strong presumption that a limitation does not invoke 112F if the word means is not used. Instead, as Williamson held, the new standard would be whether the words of the claim are understood by a person of ordinary skill in the art to have a sufficiently definite meaning as a name for structure. Here the word module did not denote structure, and also the court also mentioned that the prefix did not lend any structure to the claim. And the court then looked into the specification for the corresponding structure and did not find it. Therefore, the claim was found indefinite. So remember, we mentioned 112F is not in itself a rejection. Instead, you get indefiniteness. So here they found 112F, and then they found indefiniteness, and so the claims are rejected. And there was, so basically that answer here is this does invoke 112F. Our next example is taken from media rights. Here the phrase at issue is compliance mechanism. Media rights is another post-Williamson case. And at first it appeared from the reasoning that it was very similar to Williamson, but the court started out by saying that compliance mechanism doesn't suggest structure. However, media rights went even further by looking at every function claimed to be performed by the compliance mechanism. And you have to have sufficient structure for each of those functions. So here 112F did apply, and some of the reasoning the court mentioned was 112F might not have applied if the patent owner tried to describe inputs and outputs to the compliance mechanism, so the structure could be inferred similarly to the structure of a circuit. You might remember from one of the previous slides that circuit did not invoke functional claiming interpretation. So in media rights, if they had made it more like a circuit, they might have passed means plus function interpretation. The next example was the claimed code segment. The code segment to me kind of sounds, it's not very structural to me, but what convinced the court that this was structural was that the code segments were shown interacting with each other. So they'd have a first code segment providing an input to a second code segment, and therefore they showed interaction and they showed inputs and outputs. So this did not invoke 112F. Then my final example, there's there's at least 2 cases I'm aware of where processor was held to not invoke 112F. The first was sync point imaging. It found that the word processor itself connoted sufficient structure. And then another case, Smart Flash versus Apple, said that processor is not a nonce word, and went on to state that the processor defines a class of structures even if it's not a specific structure. Just keep in mind though, when you use the word processor, you want to show inputs and outputs when you can. I mean, even though they found this is not a nonce word, it's kind of a touchy one. I would show inputs and outputs in your specification and algorithms, implementing whatever you want to have executed on your processor. So I showed you some examples Examples here of what will invoke 112F. And again, I want you to keep in mind 112F is not itself a rejection. Instead, you might have to worry about indefiniteness rejections that come with it. So I'm going to provide some tips now on how to avoid 112F altogether, and even assuming you get 112F, how to avoid indefiniteness rejections. The first thing that is particular to software attorneys is your disclosure should show how the computer will perform each function claimed. So one of the previous cases, compliance mechanism, you want to show, even if you have one of the functions, how the computer will perform one of the functions, you want to show for each of the functions being claimed. And the best way to do that is with a flow chart. And I would recommend doing that even if you think you're not claiming software. There's always a possibility later on that the case law changes or one of the examiners gets a little picky and decides this is like a software application. So you want to have a detailed flow chart showing your algorithm. And another thing you could do is include inputs and outputs for each structure in your claim. You want to make it look like a circuit, make it look physical. One of the best ways to do that is show what the inputs are to each structure. And include structure right in the claim, even if you don't intend to invoke means plus function interpretation. And the best way to do that is describe memory or ports and etc. in your claim. And one of the last thought I have is I would not necessarily avoid functional claiming. I find some of my clients want me to add functional claims to my claim set, and one of the reasons is claim differentiation. You're showing the examiner, this is my functional claim set. Do not look at the other ones as functional claims. And another thing it does is it forces you to consider everything we've talked about today. Consider how I'm going to add structure or how I'm going to show algorithms by specification. And the best way you could do that is make sure you nail down the inventors to have them show you how each step is being performed, and so that you have a good algorithm for showing anything that's being performed by your claim. And all that is, those are my comments and hints for overcoming means plus function interpretation and the accompanying indefiniteness rejections and enablement rejections. Thank you for your time.